Hello, everybody. Welcome to class again. I got Kristen and Pam here with me. Pam's from Virginia. Kristen, you're from Texas, right?
Correct.
I remember you guys from last time. So this is great you guys are here because we could follow up on a lot of concepts that we did last time in our last session. So you're going to see a lot of them connected. So just to quickly review a few things, we're here to learn about real estate. Pass the exam is what we want to do, right? Yay, pass the exam.
Yes.
Yes.
Hey.
Okay, and just to review as well from our last class, for people who are watching this on video, this should be a key part of your studying plan. Anybody who says just do one thing, all you need to do is come to class, all you need to do is watch my videos, all you need to do is the practice questions or the flashcards is a liar. Do not rely on one thing so that you can make money and start selling real estate. The specifics and the details really should be nailed out when you do those practice questions. But by sitting here through this webinar, you will get a better idea of the bigger picture. Because if you're just doing the practice questions, sometimes it's hard to fit them in, and it makes it almost more confusing because it doesn't really make sense. But if you have a good foundation, then everything kind of falls into place very nicely. So our rules from yet last time, use the mute button appropriately. You guys know if there's kids or family or dogs behind you sneaking up. We'll pause for questions and stay on focusing on past exam. And remember, I am not a lawyer. Okay, you guys ready?
Yes.
Oh, one last thing, I forgot. And if you liked what we do, don't forget to say something nice on my LinkedIn profile, linkedin.com/Joe Juder. Okay, so what we wanted to do today was contracts and government powers. But when I was looking today at preparing this lesson, I realized there's a good amount we could go over with contracts. So we may not get to government power, but if that's really important to you, I'm happy to review it. But I really wanted to stay focused on contracts today because that's an essential part of real estate and a huge part of your exam. So let's start with this. Do you guys know the 4 essentials of a valid contract? All right, so the first one we got here, you guys read it for me.
Here you go. Capable parties. I see it right here. Yes.
Capable parties. Good. Second one. What does it say?
Lawful object.
Lawful object. Third one.
Consideration.
Most important one there. That's why we're doing this. We don't want to be poor, right?
Right.
And offer and acceptance.
Offer and acceptance.
There you go. We got to know those 4 essentials of a valid contract. You should be able to say it like blindly. Capable parties, lawful object, consideration, offer and acceptance. Capable parties, lawful object, consideration, offer and acceptance.
Yeah.
Offer and acceptance could sometimes be called meeting of the minds, mutual consent, but either way it means the same thing. You want it, I want it, great, high five, we're good to go. Okay? So you got to have those 4. So, you guys ready for your first question early on? I know it's quick, we just started. Ready?
Yeah.
Let's
Ready.
go for it.
Okay, so let's look at this question and see what you guys think the answer is.
B, it would be.
Okay, so Pam thinks B. Kristen, what do you think?
Let me see. A?
I think it's A. I'm sorry.
Wow, Pam, you're easily swayed, huh?
I jumped the gun. I had to go over it again. I agree with Kristen.
Okay.
No!
Okay, so,
okay, B.
okay, so let me give you guys a little hint with test taking. Your first impulse is almost always correct.
Yeah.
Okay, so I've been doing exam prep for going on 15 years now. And one thing I've learned is first impulse is always correct. When you second guess yourself and you're not sure, you usually end up editing it into the wrong answer. Now, obviously, there's good times to review questions and see what you did and what you didn't do right. So, and you may find some valid things like, oh, what was I doing? That wasn't right. But if you're ever not sure and you're torn between 2 answers, go with your first impulse. Okay? So, my other advice to you when you're taking the test, jot down your first impulse always. So very often when you take a test, do you guys look at a question and say, I'm going to come back to that question? Do you guys do that?
Yep.
So when you guys do that, The danger is you come back, you don't remember what your first impulse was, and also you may have run out of time by the end of the exam, you may be tired, there may be many factors. So on your scrap paper, jot down what that first impulse was, so when you do come back and your brain is drained, you're running out of time, at least you remember what the first impulse was, and you'll just fill in that answer. Because as shown here with Pam, the first impulse was correct. Okay?
Right.
So we look at this one. It's lawful object, competency, mutual consent, and consideration.
Mhm.
Performance is not a part of a valid contract. A contract is essentially establishing you want somebody to perform. It's not performance itself. Okay? So you see it here and there.
Yep.
And execution. Contract says, I want you to perform. I want you to execute this. It is not the performance itself, if that makes sense. It's an offer to perform. Okay. Next, we have capable parties. Do you guys know the story Macaulay Culkin?
Yes.
You guys may not be a fan, but we were all a fan of the first movie, right? Before he went all kooky.
Home Alone.
Yes. So what you have at capable parties is must be at least 18, sound of mind, and given the authority on behalf of a corporation, or given the power of attorney. The reason I say Macaulay Culkin is he was very famous not only for his movies, but he did something else that made him really famous in the tabloids. He divorced his parents.
Oh, yeah.
He became an emancipated minor. Okay, right there. He became an emancipated minor, which means under 18, and the courts gave him the authority to act as an adult, a capable party. There's other ways you could do this. You could get married, makes you a capable party, and if you serve in the military. Further details I'm not sure about, but you do understand that capable party is an essential part of a valid contract. Therefore, if somebody's not of sound mind, then they sign a contract, that contract becomes not valid. All right, so what do you guys think the answer is here?
Unenforceable, D.
Unenforceable. Good. All right there. He has not been emancipated. He's an unemancipated minor. Okay, so you were correct before. Excellent. Okay. Okay, lawful object must have a legal purpose. Contract with an illegal purpose is void. Can you have a contract to kill?
You can.
Not
You
according
shouldn't.
to the law.
You shouldn't, but yeah, no, it's illegal.
Right. So contract to kill is obviously a terminology is great for movies and news. But legally, that's no contract at all because it's an illegal purpose. Okay?
Right.
So you must have a legal purpose. That would make it void. All right? Okay, consideration. Love and affection can also be considered consideration. All right? So it doesn't have to be money. Technically, consideration is anything of value. And this is important because on your exam, they'll trick you and they'll say money. And you think money, oh yeah, obviously money. I'm selling, I want money. I don't want a hug. But technically, consideration is anything of value. Could be love and affection, could be money, could be a new car if you want. And here's the one, offer and acceptance. Okay? So offer and acceptance is pretty clear with everything. I want it, you want it, great, shake hands, and you're good to go. I wrote here it must be non-illusory. What do you guys think I mean by that? Non-illusory.
Something that is must be clear, so it can't be must be clear in character, non-illusionary.
Well, let me ask you guys this. How much is a house worth in your area?
$500,000.
$500,000. Okay.
$500,000.
$500,000. So can I buy a house for $500,000?
Yes.
Sure. If you had told me the house is worth around $500,000, can I buy the house? No. So you couldn't say homes in Virginia are worth a whole lot of money. I'd be like, how much? It's just like a whole lot. Well, what's a whole lot? Just trust me, it's great. It's like a great deal. It's like a ton of money. You'll like it. Give me the exact amount. It's like 500-ish or something. All right. Could you do that? No. You said $500,000. That's 500 grand. Done. All right. That's what it's worth. That's exact. Illusory would be if you said, I don't know, somewhere like half-ish, give or take, whatever, $10. Okay?
Yeah.
That's what they mean. It must be exact. Okay, do you remember the OREE rule from last session?
Yes.
Okay. Tell me again about that OREE rule.
OR is the giver, and EE is the one who receives.
Yes. So last session we said lessor, vendor, trustor, optionor is the giver, the proprietor for your pleasure. Offeree, lessee, vendee gives me property, makes me happy. Okay. Offeror, offeree. Offeror's giving an offer. Offeree receives an offer. Okay. And what's a counteroffer?
The receiver changes the terms to the giver.
Okay. So look at it like this. The offeree becomes the offeror.
So it's flipped. Okay.
Think of it in those terms.
Mm-hmm.
So many people often think a counteroffer is a modification of the original offer.
Right.
And they think that because in real terms, it's true. That's kind of what it is. You're modifying the original offer. But technically and legally, it's a brand new offer.
Mm-hmm.
In most states, when you make an offer on a property, it says 1 somewhere on the contract. And then when you respond, that's number 2. Okay, it'll go back 3, 4, because that's the second offer, third. It's a brand new offer. So it is not you offer 500 grand to me and I modify it, let's make it 510. That's not what happens. What's happening is I'm saying I will terminate your offer for 500 grand for my house, and in turn I will make you a new offer of my house for your 510 grand.
Mm-hmm.
So it's a brand new offer, so it terminates the original offer.
Mm-hmm.
All right, so here we got this one.
A. Well, actually D.
Okay, Kristen says C. You say D. Let's see what the answer is here. All of the above. It is a new offer, so it requires the signatures. So when you have a counteroffer, people have to sign on it. And it's a rejection of the original offer. Remember, it terminates that original offer. Okay?
Right.
All right. It's another question for you guys.
In writing. A.
Okay. Good. So that is excellent because you may get this wrong in real estate exam because conventional wisdom is you put contracts in writing. Obviously you do to make it secure. But it is not one of the 4 essentials. There are things called oral contracts, even oral listings. So people get this wrong because real estate contracts are in writing. But you got to remember what the question asks. What are the 4 essentials of a valid contract? So this is one people get wrong all the time. And remember, our mutual consent, capable parties, lawful object, and consideration. Writing is not one of the 4 essentials. If anything, call it like a 5th essential, kind of like a 6th sense, if you will, because it's just so common and such a regular part of contracts. Statute of frauds, and this leads me to the next slide, determines which contracts must be in writing. So it says which contracts must be in writing, sales contracts, deeds, mortgages. But remember that the previous question said what is not an essential element, period. It didn't specify. So that question was alluding to all contracts to make contracts a contract. This slide shows you which types of contracts needs to be in writing. Deeds, mortgages, things of that nature. All right, some states allow oral listings for less than 1 year. A broker needs an employment contract.
Yeah.
Time is of the essence is on contracts. That is a key element of your listing contracts. Okay? Offer contains a time period and an expiration date. Typically, you might say 90 days, okay, or whatever the duration of the listing may be. As is clause. Be very careful with this one. So as is, what does that mean? What does an as is clause mean?
Is here find the property with existing conditions. So as is, as it stands.
Yes. The catch is, though, just because it as is doesn't mean that you could keep hidden things. You still have to disclose what is. So it may say as is, but people tend to say it's as is. You see it, that's what it is. You still have to disclose all the things that are defective about the property.
And so that's to protect. That's to protect everyone.
Right. What you're saying is, I'm selling it as is, and I'm not going to be required to make repairs.
Right.
An important distinction. We went over this last time. We were talking about leases. So we said this thing about assignment in the last session. Do you remember what an assignment was in a contract? So we talked about it in terms of a lease last time. We talked about assignment and sublet.
Oh, I remember.
So an assignment is when you get rid of the contract right.
Mm-hmm.
So when we talked about a lease, we said sublet and assignment. A sublet is when you give somebody the right to use the property, but you still have responsibility. Assignment is when you give the responsibility as well. Okay? So the contract is assignable unless the state law forbids it. And remember, we said that landlord has to state you are not allowed to sublet or assign. If he doesn't state it, then they could do it. Remember, I said in most conventional leases, it states you cannot sublet or assign.
Mm-hmm. Okay.
All right. Assignor, assignee. Remember that OREE rule? Assignor is the one transferring. Assignee is the one receiving that responsibility. And here's my example from last session. You are the assignor and the new owner is the assignee. The landlord would now expect the lease payment from the new owner, the assignee.
Mm-hmm.
Novation. Assignment does not relieve the assigner from liability unless novation has been granted. What is a novation? You guys ever heard this? You're going to hear a lot of Latin. Ad valorem, nova, lease pendants. It's a lot of Latin that comes up. And this is an important one. Do you know what nova stands for?
New. Okay.
Nova is Latin for new. The substitution of one contract from another and can release liability. Nova's Latin for new. Got to know that one.
It would be novation.
There you go. Excellent. Good. Just remember, nova, new. Nova, new. You guys remember the last class, and I'll re-emphasize it in this one, the importance of narrowing down things to key words. So nova, new. Last time I said real property, immovable. Personal property, movable. You really want to nail things down to the most minimum information you have to remember to make it easier for you to pass. So when you see Nova, you see new, you're good to go. This obviously doesn't use the word new. Person is substituted for another in a contract. It insinuates new. So novation, new. Got to remember that. Specific performance is basically making me do a certain act. For example, if I promise to sell the house, you can actually sue me to sell the house if you fulfilled all your parts of the contract. Okay? You're suing me to perform a certain act specifically. This is a lawsuit between buyers and sellers. This is not between the brokers. Brokers do not sue for specific performance. Okay? Rescission. Rescission is almost like the opposite of assignment. All right? You're getting out of the contract. You're not giving it to somebody new. You're returning the contracting parties to the same legal position they were in before. It's a way to void out the contract. All right? Are we all good? Any questions?
No, this is good. It makes sense.
All right. Good.
Makes sense. Uh-huh.
All right. This is one that I love, the earnest money deposit. So you guys want to sell a house. What do you get right from the beginning to say that this person's serious about the offer? So I want to buy your house, okay? And I say, I want to buy your house. Kristen, Pam, I'm interested in buying your house.
I'm really excited. After being very excited, I would think that we need to make some type of good faith on you wanting to buy my house. If you want to buy my house.
Yes, because let's be honest. If I said to you guys, I want to buy your house, just right now, I want to buy your house, you'd be like, that's nice. You know, you're not really taking it seriously just yet. You kind of just look at me and you're like, great, good for you. Whoopity-doo. But if I showed up to your house and I said, I want to buy your house and here's $10,000 to say I want to buy it, and if I don't follow through with this, assuming conditions are met, you keep that money. Now all of a sudden you're thinking what? Oh, okay, he's for real. Right? He really wants this.
Right.
In other words, I'm making an offer, okay? Well, it's my little picture of a guy wanting to buy a house and agree. I'm making an offer, and I'm saying, I want to buy your house, and I need to put down a deposit. Yes, the contract is needed there. So it's the first part of that contract that says, hey, I need you to put that deposit down. Okay? So what does this sound like? If I'm offering to buy your house and I need this deposit, it's similar to me saying I'm making a proposal to buy your house, but I need something to show that I'm serious. Proposal, serious. What comes to mind immediately when I say the word proposal? If I'm going to propose to you, what comes to mind?
A contract. I mean,
marriage. Thank you. Kristen said it. Marriage. Excellent. Yes. Yes.
Put a ring on it. Yep.
And I want you to remember this because it's the same thing. And I don't want to deflate a lot of people who love the idea of engagement rings and all that. But originally, that's what it was. Before, it was like a beautiful engagement ring. It was saying, here, I want to marry your daughter, and here's my deposit. And that's what it was. It's not very romantic and sexy, but in modern culture, we've evolved it to this beautiful romantic thing. But at its core, it was a deposit. That's what it was.
Right.
Okay? So if I showed up to you and I said, Kristen, Pam, will you marry me? And I didn't have a ring, you look at me and think, loser, right? He's not serious. What is he thinking? What is he doing here? You need a ring, right? And if I showed up with a ring, all of a sudden you say, wow, he's serious. And you'd be very excited. And that's when you laugh and smile and cry and we hug and all these great things because now I have that ring to show that I'm serious about my offer. That's my earnest money deposit. And we get married and live happily ever after. So you may say, if you follow me with this logic, if you take my deposit, the ring, when you say I do at the altar, finally when we're officially married, escrow is closed. Okay, if you want to think of it like that. So that engagement period is kind of like that escrow period, where we're going through contracts, making sure everybody's a good guy and all that kind of things. Okay?
Yes.
All right,
Okay.
so use that analogy. And very similarly, if I gave you an engagement ring, said, I love you, you're the one for me, and then I went and cheated on you and did things with other women, and it was a horrible guy, would you give me my ring back?
No, I would not.
Exactly.
I'll keep the ring, but
I'm keeping it and kicking you to the
Exactly.
curb.
Yes. I could try and get it back, but it'd be one hell of a fight.
yeah.
It's the same thing with the earnest money deposit. If I give this to you and then I violate the contract, all the terms we met, I may be able to get that money back, but it'd be one hell of a fight. And you put in
No,
those,
that's good.
you put in those terms, it's the same thing. I mean, that
Yep.
ring is a deposit. It's the same thing. I'm putting an offer. I'm ready to go. You like the little picture of the
Yep.
married couple? Yeah.
I
Okay.
will never forget that.
Yeah. But just remember, I give you a ring, and then once we say I do, escrow is closed. So when I give you that
Mhm.
deposit, escrow's open. You have the contract, deposit, we're good to go. Okay, so I mentioned this before earlier in this lesson, but I want to really hit home with it. This concept of valid, void, and voidable. I didn't really mention it a lot, but I mentioned it a little bit. It's very important you understand the difference between valid, void, and voidable. It's a very simple concept that people confuse all the time. Okay? Do you guys want to take a stab at it really quick before I go into it, or would you like me just to go right into the explanation?
I could try to take a stab at it.
Okay, go for it.
I think valid is it's true.
Okay?
True. It's true. Void means it is there's something within the contract, or it could be. I guess it's not always referring to contracts, but it's void. It's no good. It's not usable for whatever reason. And voidable is potentially void.
Yeah. So I actually gave an example of a void contract before, earlier in this lesson. If you remember my example of the contract to kill,
Oh, right. Right. Okay.
that makes it void. So let's go through these a little bit. So valid. Let's put in the simplest terms possible. I want a blue house. I offer to buy the blue house. We signed a contract for a blue house. You give me a blue house. Right now, what is that?
It's
That's
valid.
valid. I want a blue house. You gave me a blue house. We're good to go. All right? But now, here's a question. What if I go to buy the blue house and the house is green? Is that valid, void, or voidable? Kind of gave the answer in my slide. Should have thought ahead on that one a little better. Well, let me ask you this.
Voidable.
Why is it voidable? So I obviously gave her the answer before I went to the next slide, but why? Why is that voidable? I wanted a blue house. You gave me a green house. Why is that not void? Because you're not coming through with your part of the contract.
Okay.
So why is that not void? Why is that voidable?
Could it, I don't know. I'm gonna take a stab at it.
Misrepresentation.
Okay. And once again, when you guys study for this, and this is also an excellent practice to get into, try and simplify everything. When I say it's excellent practice, because you guys are going to work with clients, a lot of complicated concepts. The more you can simplify stuff, the more relatable you'll be, and the more desirable you'll be as a real estate agent. So the most simple terms, I wanted a blue house. You gave me a green house. I'm upset it's not blue. But after looking at that green, I kind of like it. It kind of works for me. I'm kind of into the green. Didn't think of it before, but green works for me. Should I still have the right to follow through and purchase that house?
Sure.
Exactly. That's why it's voidable, not void. Because even though you didn't fulfill your part of the contract, I still want that house. Void, like that contract to kill example, I don't have the option to follow through with that. I have the option to follow through with this. So it's voidable, not void. All right, there's my guy with the greenhouse. So voidable, duress, misrepresentation, fraud, all these are voidable. Okay, that example was misrepresentation that I just gave right now. All right. So following through that logic, let's talk a little about duress. Okay. If there's a gun pointed at you and the guy's saying, buy the house, is that void or voidable? I mean, you have a contract in front of you. There's a guy with a gun to your head saying, if you don't buy this house, I'm going to do some horrible things here. You have to buy the house. Is that void or voidable?
I would say, well, the gun has me a little frightened.
Right, so you're frightened, you're scared, all these horrible things.
Yeah.
Right? Is that
Right.
void or voidable, the contract?
Well, I would think the gun.
Well, let me ask you this, okay? You go to, this guy makes you sit down at the table, sign this contract, gun to your head, all these terrible things, okay? You do not have to follow through that purchase because obviously you're under duress, okay?
Okay.
You're being
void.
threatened. You're under duress. So according to the law, you do not have to follow that contract.
Right.
But wait a minute. What if, as all this horrible things is happening, you look at the contract and you're like, man, the gun's really not necessary. This is a great deal. I don't know why you're freaking out about this. I kind of want this house, okay? Do you have the right to follow through and purchase it?
Yeah.
Yes.
Yeah, so it's voidable. So you could actually turn to this horrible person and be like, excuse me, sir, the gun's not necessary. This is a tremendous deal. I mean, you really went overboard with this. I was planning on getting this anyway, and you're just making this awkward now. Okay? So that makes it voidable, not void.
Right.
Duress, threats, misrepresentation. What it does, it gives you the option to rescind. Okay?
Mhm.
So think of it like this. Somebody else acting inappropriately shouldn't take away your ability to follow through with a contract. Okay? That's why it's voidable and not void. All right?
Yes.
Important distinction there. And people make that mistake all the time. They have examples on exams where you're being threatened. Does that make it void? People are like, oh yeah, threat's terrible. Void. No, voidable. Okay. So void contract lacks one of these things: mutual consent, lawful object, consideration, or capable parties. Mutual consent, you agree, lawful object. Okay. Consideration, there has to be a purpose for this. And capable parties. All right, so here we go. We got a question here. Tell me what you guys think the answer is. What do you guys think?
Only by Bob.
All right. Good. Excellent. Okay. And is this contract void or voidable?
Void.
I say voidable.
It's voidable. So remember, Bob has the option to go through with it if he wants to. So Bob could make it void, but he has the option to make it voidable. Excuse me. He has the option to make it void because it's voidable. All right, here we go. What do you think the answer is to this one?
Void.
Yeah.
Okay. Voidable.
Ah.
Yeah.
Still the I guess like the option. Okay, at least contain.
Yeah, so it's voidable. Because remember, so here, if you look, the lease contains an assignment clause requiring the consent of the landlord. So this requires your consent as a landlord. I, as the lessee, assign the lease without your approval. You're angry, right?
Mm-hmm.
But once again, so you have the option to say, no, you can't do that. I never agreed to it. But
Right.
what if you assigned it to Chris did, and I'm like, you know what? Pam doesn't sign contracts. She doesn't agree to anything. It's really annoying. I like that she assigned it to Kristen. I didn't say she could do that, but Kristen seems like a great person. So as the landlord, don't I have the option to follow through with that? So yeah, because I like
Yes.
the idea that you assigned it to Kristen. Just because you acted inappropriately by not agreeing with things and doing stuff shouldn't take away my option to follow through with Kristen. Okay, so it's voidable, not void. Void would insinuate I can't follow through with a contract with Kristen, but because we didn't agree, it's voidable, not void.
Okay.
All right. What's the answer to this one?
Oh, that's void.
Excellent.
I agree.
Good. And I use that example, contract to kill, because it just really sticks in your mind. It's a horrible, morbid example, but it also devalues every James Bond movie. Wasn't that contract? No, that was License to Kill, right? Not Contract to Kill.
Yeah.
But it was all the same premise, okay? So it makes it void.
Mhm.
All right. So at this point, we did the basics of contracts that hopefully give you a good basis to kind of follow through with on your exam and do contract questions. There are more details I could go through with contracts, and if you want me to, I'm happy to do it. Just send me the information you want me to go through, and I could kind of put together some slides and questions to help work on those. But that is a good groundwork of contracts. That was a good 40, 50 minutes we went through there. So I'm kind of thinking that we leave government power for another day, or would you guys like me to go through government power quickly?
I would love you to go through it. It's up to Kristen if she's got the time. Yeah, I'd love to.
I have the time. I have painters here in my house, though, and it's so distracting right now. I'm struggling.
Oh, okay.
But I will give it my all. I really, you know what I'm interested in is
Yes, what's that?
discussing wills and how property is distributed after someone passes, whether they have a will or not, if tested, intested, all of this.
Excellent. So I could definitely go over that. I'm very well informed of that topic. So I would like you to email me a little bit later what you'd like me to go over. And then how about we say Friday, I'll cover that topic, because that'll give me time to put together some nice slides and a nice little lesson for that one.
Perfect.
That'd be awesome, Joe.
Yeah.
Thanks.
So in test date, and you're talking about how it's divided, I will caution you, a lot of that depends on state law. So, and we will go over that though.
Okay.
Okay? With distributing to errors and whatnot. So email me that, and then I will see what we could go over and what we can't go over with that, and I'll try and do my best to help you out. And the same thing goes out to anybody listening. But yeah, so let's plan on that on Friday. Okay, here's what I'll do. Let's go over the government power quickly.
Okay.
And see what we could learn here. Okay? So first thing I want you to do is remember the name Pete. Okay? So I want you to remember the name Pete when we're talking about government powers. All right? What it stands for is police power, eminent domain, taxation, and escheat. Okay? These are rights that individuals would not have. Police power, eminent domain, taxation, and escheat. And please utilize these memory techniques the best you can. Last week, you remember we said Maria. What was Maria for?
Method, adaptation.
Good.
Oh gosh, relationship. Oh.
Relationship, intention, and agreement.
And agreement.
Yeah. So method, adaptability, relationship, intention, and agreement. Okay. So this one, Pete. Police power, eminent domain, taxation, and escheat. I'm assuming you guys heard this before in your classes, right? Your teachers told you this one, Pete?
No, I didn't hear it.
Oh. Well, I'm glad you heard now, Kristen. Now you've heard it. Good. Okay, so first we got police power. We're not talking about the actual police, are we? Actually, far from it.
No.
Police power is state's inherent right to regulate the individual's conduct or property to protect the health, safety, welfare, and morals of the community. Health, safety, welfare, and morals. When you're taking the exam, okay, another little hint for you on your real estate exam, and hopefully these hints really help you. The government's always going to be portrayed in a positive light. Whenever you hear a question asked about the government or the state, the answer is never going to be they stink, they're horrible. It's always going to be something positive. Health, safety, welfare, morals, Superman, heroes there to save the day. Okay? So just remember who's given the exam. Okay? So police power for the health, safety, welfare, and morals of the community. When we talk about police power, we're talking about zoning, building codes, and rent control. Thank God for police power. Okay? Because without these things, it would be terrible. Can you guys give me an example of zoning?
For your schools,
Yeah, schools, churches, businesses, they all are zoned.
Right. Well, let me ask you this. Do you want to live next to a gas station?
no.
And a gas station doesn't want to be near you either. Thank God for zoning. Okay, that's where zoning comes in. It prevents things of that nature. So it helps sector the community so we're all living in our appropriate areas. That's why there's houses next to you and not gas stations. Building codes, obviously, to make it safe, and rent control, point of controversy for a lot of people. But those are police powers, and it's there to help the community function as part of a larger master plan. You guys ever been to Los Angeles?
Yes.
Yeah, there's no master plan there. At least there wasn't in the beginning. It was chaotic. And you probably noticed the 10 goes to the 101, goes to the 405, and sneaks in. All of a sudden, there's Pasadena, Hollywood. It's all over the place. And that's why they have that horrible traffic. So it wasn't such a plan. They tried to fix it now. But in the original times, it was a little bit hectic. What city are you in, Kristen?
I'm right outside of Houston. I'm in Sugar Land. It's a
Houston.
suburb. Mm-hmm.
Oh, okay. I've been to Houston. I saw the monument, Kennedy, all that kind of stuff. Actually, that was Dallas. All right. Edit that out. Okay. Eminent Domain. Doesn't that sound scary to you guys? Eminent Domain. Sounds kind of like Star Wars. Eminent. Because when you think something's eminent, what do you think of? You think it's like inevitable and people are
It's
coming.
gonna happen.
Huh?
When I hear it, I think of that it's going to happen. That it's imminent.
No, it's very scary. It's like a scary word. Eminent domain. And for good reason. It is like all-encompassing, all-powerful. It's the government's ability to take over the property for public use. So basically, if I'm the government, I could take over your property whether you like it or not. It's eminent, my takeover, if you want to look at it like that. Now, it sounds very scary, and I say that to help you remember the exam. But in reality, it's a very important part of having a functional city. Because if there's a highway that has to be built in order for people to get to work and go to their jobs, and your house is right in the middle of where the highway would be, well, sorry, we got to build that highway so the rest of the city could function. It stinks for you, but just compensation would be paid to you. You would get money because the city needs that area to function so they could have their highway go through. And they do this through the power of eminent domain. Okay? So they take over property for public use. Public utilities, highways, railroads. As I said, it may not be good for that property owner, but it's necessary so the city could function. Okay. That process of giving you the money is called condemnation. You ever heard this word before?
Yeah.
Yes.
So this is where I'm paying you for that property. So condemnation is the process by which the property of a private owner is taken for public use under the right of eminent domain. Just compensation is paid to the owner. So that's the process of you getting money. What if they don't give you the money? What if they say, you know what, we didn't really take your property, but you're like, the highway's going right past my backyard. You just ruined my property. So they decide not to give you the money, but you think you deserve the money. You think the property was ruined. What do you do?
File suit?
Yes. You actually sue the government. And what this is called is inverse condemnation. Okay? Inverse condemnation is a term used in the law to describe a situation in which the government takes private property but fails to pay the just compensation required by the Constitution. So you are actually literally suing the government, just as Kristen said, to get that money. Right. And here's some examples I put. City widens boulevard. Market claims it lost all its business, so they could sue for inverse condemnation. The market wants the value of the entire parcel, including the market building. There's different situations where it comes up. But remember, inverse condemnation is basically you're suing the government because they didn't give you just compensation when they took your property under the rights of eminent domain. Taxation, you all know what that is, right? Charge on real estate to pay for services provided by the government. Escheat is when the property reverts to the state ownership when an individual dies without heirs. Think of it like this. The government cheated to get the property. It's not theirs. Why do they own it? They got it. They cheated. So escheat. So if you have no heirs, no family, in all reality, they're not cheating. They're saying if we can't find anybody to give this to, then it reverts to the government. Okay, that's escheat. And those are your four primary government powers: police power, eminent domain, taxation, and escheat. All right. So what's the answer to this one?
B as in boy, escheat.
Good. Excellent. All right. So that was a brief going over of government power that actually didn't take as long as I thought it would. So we're good to go for today. And I'm going to do this again on Wednesday. And hopefully you guys join in again. This just really helps me go through and perfect what I'm doing here. If you have any feedback, please write it for me, and I'd really appreciate it because I really want to be able to put forth a good product here and do a good thing for everybody. So I hope you guys liked it.
Wonderful.
I did. Thank you so much.
All right, so Wednesday it is, and then Kristen, just jot down stuff you want me to go over, and I'll see if I can put together a presentation on Friday.
Awesome. You're awesome. Thank you.
You're welcome. Okay.
Thank you, Joe.
Okay, see you guys later.
All right, see you Wednesday.
Okay, bye.
Bye.